It's 9:03 on Wednesday, March the 31st. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio,
Here.
Farmer, Griffey, Hardaway,
Here.
Howell,
Here.
Lamberth, Moody, Russell,
Here.
Sexton,
Here.
Chairman Doggett.
Present.
Mr. Chairman, you have a quorum.
Thank you, ma'am. Any personal orders before we begin this morning? Seeing none, we're going to go through the calendar right quickly and look at some things that we need to take care of. Item number 1, House Bill 1434 by Representative Sherrill will be rolled to the last calendar. Item number 5, House Bill 382 by Chairman Crawford, roll 1 week. House Bill 1062, item number 9 by Chairman Hawk, roll 1 week. Item number 19, House Bill 1084 by Chairman Dixie, off notice. Item number 29, House Bill 413 by Representative Lamar, roll 1 week. Item number 30, House Bill 1533 by Representative Lamar, roll 1 week. Item number 33, House Bill 600, Representative Hodges, roll 1 week. Item 34, House Bill 601, Representative Hodges, roll to the first calendar of 2022. Item 42, House Bill 352 by Chairman Farmer, off notice. And that will complete that order of business. Item number 2, House Bill 1430 by Chairman Moody. She is not in the room, so we'll roll her a few places. We'll roll three spots. And we'll come up on item number 3, House Bill 1339 by Chairman Curcio.
Thank you, Mr. Chairman, and I do have an amendment coded 5166, which I wish to move.
Okay. We need a motion and a second on this before we proceed, please. Okay. Amendment number 005166. I need a motion and a second on the amendment.
Motion.
All right. You're recognized.
Thank you, Mr. Chairman. The amendment makes the bill. This legislation would allow the court to permit remote testimony by a forensic analyst in any criminal proceeding, but only if the state has provided a copy of any report produced by the forensic analyst that the state is seeking to admit into evidence through remote testimony at least 15 days prior to the proceeding. Most importantly, the defendant agrees to permit the remote testimony, and the court finds the defendant's agreement was knowing and voluntary, and finally, that the court and the state agree to permit remote testimony. So everybody involved would agree to allowing this to happen, otherwise it wouldn't go forward.
Okay, thank you. Any questions on the amendment? Representative Beck.
To the sponsor, have you had any pushback from any of the stakeholders?
Thank you, Mr. Chairman. No pushback, and just to further that point, this bill was actually brought by Representative Ogles, and I'm carrying it on his behalf. So when he transferred the file to me, we did check to see if we had any issues, and no one reported any.
Very good. Thank you so much.
Thank you.
Any other questions? Any objection to voting on the amendment? Seeing none, we're now voting on amendment 005166 to be placed on the House Bill 1339. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. We are now on House Bill 1339 as amended.
I renew my motion.
Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1339 on the full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. Now move on to full criminal. Thank you.
Thank you, Chairman. Thank you, Committee.
Next item on the calendar, item number 4, House Bill 1599 by Leader Lamberth. We're going to roll him 5 spaces. That brings us back to House Bill 1340 by Chairman Moody. We're going to roll, without objection, we're going to roll that bill to the hill. Item number 6, House Bill 1171 by Chairman Terry. Have a motion and a second. You're recognized.
Thank you, Chairman and Committee. And there is an amendment, 5826.
Let's see here. Yes, amendment number 005826. I need a motion and a second on that. All right. You're recognized on the amendment.
Thank you, Chairman and Committee. While the U.S. does not have a federal firearms registry nor a plan for confiscation, there is certainly discussion of it, including a bill that has been filed recently entitled the Firearm Licensing and Registration Act. In 2015, the Tennessee General Assembly passed Public Chapter 380 based on anti-commandeering doctrine that says that the state or any local subdivision will not use funds, personnel, or property to enforce any federal law that is against Tennessee law or the Constitution. This bill has 2 main goals in the event that the feds try to infringe on our Second Amendment rights via confiscation or registration. First, it puts teeth in Public Chapter 380 by adding a Class A misdemeanor to a state or political subdivision employee that discloses firearm information for the purposes of confiscation or registration. And secondly, it grants a cause of action for firearm owner against an individual who discloses their firearm information for the purposes of registration or confiscation. The bill does have exclusions for criminal investigations or if required by an FFL.
Thank you for that explanation. Any questions for the sponsor on this amendment? Questions been called on the amendment. Seeing any objections? Seeing none, we're now voting to adopt amendment number 005826 on the House Bill 1171. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We are now on 1171 as amended. Representative Beck.
Thank you. And Chairman Terry, so this is not, you're trying to do a preemptory strike here in case there, as we sit here today, there's no federal registry and there's no federal requirement, but you're just doing something that you think is prudent to head something like that off.
Absolutely.
Am I getting that right?
Absolutely.
Okay, thank you.
Any other questions? Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1171 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on. Thank you.
Thank you, Chairman and Committee.
Next item, number 7, House Bill 1312 by Chairman Terry. Have a motion and second. You recognize.
Thank you, Chairman and Committee. There is an amendment 004243.
Motion and second.
All right.
All right. You're recognized on the amendment.
Thank you, Chairman and Committee. This issue was brought to me by a constituent, and it's truly a concept of self-governance on their part. This was a mother whose daughter rolled her vehicle in a fatal car accident one evening. Pictures were taken at the scene, and the mother became aware of those pictures and inquired about their potential use, including for training purposes. And she realized that as a parent and as a victim, she did not have parental rights to keep those graphic photos of her daughter confidential. The goal of this legislation as amended is to safeguard the privacy of deceased minors. All photographic evidence of a fatal motor vehicle accident that depicts a deceased minor at the scene of the accident is to be treated as confidential and not open to public inspection. But if the custodial parent or legal guardian wishes, they are authorized to waive the confidentiality.
Thank you for the explanation. Is there any questions for the sponsor on the amendment? Question's been called on the amendment. Any objection? Seeing none, we're now voting on adding, I'm sorry. It's on the bill, okay. We're now voting on adding amendment number 004243 on the House Bill 1312. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You adopt. We're on House Bill 1312 as amended. Do you mind withdrawing that so that we'll get Leader Lambert can ask a question here? Thank you.
Yes, sir, Mr. Chairman, and I apologize for being a bit late. I was in another committee. On the accident reports on this, when I was reading over this amendment, and I should have caught you on this beforehand, is there an exception within this for Rule 16 for purposes of discovery? And I was trying to find that in the amendment, and I knew you'd be ready for that question, but I just want to make sure that we're not affecting discovery.
Yes, thank you. In Section 1, Part 3A, restriction of the application of Rule 16 of Tennessee Rules of Criminal Procedure in any court or the disclosure of information required. So it's excluded. It's in there.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I just want to get that on the record that it is excluded. I thought we were covered, but just want to make sure. Thank you.
Thank you.
Thank you. Any other questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're now voting on House Bill 1312 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal.
Thank you, Chairman of the Committee.
Is she ready? Okay. We're now on item number 8, House Bill 109 by Chairman Hulsey. He's not in here. We're going to roll him to the hill. Brings us back to item number 4 on your calendar. Item number 4 by Leader Lambert, House Bill 1599. Motion. Second. Your motion is second. You're recognized.
Thank you, Mr. Chairman, and this bill is exactly as it appears. It is for additional assistant district attorney positions and supporting staff.
Thank you for your explanation. Any questions for the sponsor? Question on the bill. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1599 on the full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. Move on to full criminal. We're now on item number 10. Item number 10, House Bill 1433 by Chairman Holsclaw. Motion. Second. With a motion and a second, you're recognized.
Thank you, Chairman, Committee. Y'all look very somber this morning. Basically, HB 1433, it has an amendment, which is drafting code 5396.
5369, maybe?
Yeah, that is correct.
You have a motion, you have a second, you recognize on the amendment.
And basically what this bill does, it changes the charges from a Class E to a Class C felony when discharging a firearm from an automobile. And, you know, I reckon got this basically from watching TV and stuff from a standpoint. People don't think a thing about, you know, if you cut them off, you know, used to they blow the horn, now they pull out a gun and start shooting. So we need to add some stiffer penalties maybe to reduce this if possible.
Representative Beck.
Good morning, Chairman. We'll try not to be too somber on you this morning. Chairman Moody and I were just discussing, you said from an automobile. Does this include any vehicle or just automobiles?
It says motor vehicle.
Okay, that's what I told Chairman Moody. She did not believe me, so I had to clarify that with you. Thank you.
Chairman Moody, you have anything you'd like to add to this?
I'll just let it go. Thank you for clarifying that.
You're welcome.
Any other questions? Leader Lambert.
Question on the amendment.
Question has been called on the amendment. Any objections? Seeing none, we're now voting to adopt amendment number 005369 on the House Bill 1433. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You adopt. We're on House Bill 1433 as amended. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1433 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Move on to full criminal.
Thank you, committee members.
Thank you.
I like your jacket.
Thank you. I thought he was talking to me. Maybe not. I don't know. He was talking to you. All right. Item number 11, House Bill 26 by Chairman Todd. Motion. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. Glad to finally get to see you guys in here. Y'all been doing a lot of work and staying late, I know. House Bill 26 is what I'm calling a self-defense cleanup bill. One of our most seasoned attorneys in this building brought this to me a couple of years ago as we were discussing some other legislation, and said that over the years he has found, not only from a Supreme Court decision, but also from talking to other folks and doing research, that we had an error in the law that is really a trap for folks. And what it says currently is that you can use the defense of self-defense as long as you're not involved in unlawful activity. And that is the trap. What is unlawful activity? And the Supreme Court told us years ago that that is, in fact, something that needs to be changed. And so what this does, it defines what that activity is. And so that is the essence of this bill. It just puts in code what the definition is, what things are excluded from self-defense.
Thank you for that. Any questions for our sponsor, Representative Beck?
Thank you. And to the sponsor, I'm a little confused on this, and I read it. It seems like you can now claim self-defense if you're committing a B misdemeanor or lower. And why? I'm a little confused on this. Can you straighten me out, Mr. Sponsor?
Yes, sir. Thank you, sir. So this would change unlawful activity to conduct that would constitute a felony or Class A misdemeanor. That's what the bill does. So instead of saying unlawful activity, it defines it as if you're committing a felony or a Class A misdemeanor, you could not use self-defense as a defense.
Representative Beck?
But if you are committing a B misdemeanor or lower, you can use self-defense as a defense. Is that correct?
I believe that would be the assumption.
Okay, and what would be, since I don't do criminal law, what would be some of the offenses that are Class B and C offenses?
I'm going to look and see if I have that list. I have had it in the past, so
Thank
I'm going
you,
to check
sir.
to see if it's in this file, because we went through that with legal to make sure that we're not including things that shouldn't be included, and their recommendation was this definition, and I don't know that I have that.
If you don't have the list, we can go out of
I don't have
session
that list.
and ask from legal services.
Please,
I almost said out of
Mr.
service.
Chair.
I almost did it. We'll go, without objection, we'll go out of session and hear from legal.
Michelle Fogarty, Legal Services. There's a long list of offenses that are a Class B and a Class C misdemeanor. Would you like for me to read them all to you?
Let's just read B.
Okay. 3913-101A3, assault, offensive or provocative physical contact, communicating a threat concerning a school employee, indecent exposure with no statutory aggravating factors, public indecency, first or second offense, punishable by a $500 fine only, prostitution under subdivision B1, disclosure of surveillance image captured via unmanned aircraft, falsely reporting credit card or debit card lost, stolen, or mislaid, issuing false financial statement, deceptive business practices, fraudulent transfer of a motor vehicle, failure to disclose location to the owner, interfering with customary agricultural practice on animals, removing electronic or radio transmitting collar from dog to prevent owner from locating dog, leaving fire near woodland unattended, aggravated criminal trespass other than habitation, hospital, or school, mailbox vandalism, defacement of state property with graffiti, throwing or shooting object at train, bus, motorcycle, or watercraft, criminal littering, hauling litter in unsecured manner, maliciously inducing contaminant or virus into a computer system, damaging animal facility or freeing animals therein with damage of less than $500, disseminating smoking paraphernalia to a minor after 3 prior violations, misuse of official information by a public servant, resisting stop, frisk, halt, arrest, or search with no weapon, or obstructing service of process, use of radar jamming device to interrupt law enforcement signals, abandonment of airtight containers, seller of radar detection or jamming devices, disrupting or obstructing meeting or a procession, obstructing a highway or other passageway, disorderly conduct at funerals, gambling promotion, possession of a gambling device or record, making a lottery, chain letter, or pyramid club, sale of a lottery ticket to a minor first offense, failure to file charitable gaming financial accounting, unlawful sale of alcoholic beverages without a license, possession of a still, possession of software for purpose of interfering with operations of a ticket seller, unlawful possession of a weapon with intent to go armed, second or subsequent offense, carrying a firearm on school property absent an intent to go armed, confiscation and disposition of confiscated weapons in an unlawful manner, violation of a handgun permit law not otherwise provided, fine not to exceed $500, possession of a weapon on posted property, displaying in a threatening manner an imitation firearm, conveying dangerous materials to a metals recycling facility without consent, and failure to comply with or enforce the Children's Act for Clean Indoor Air. Those would be the Class B misdemeanors.
Yes, sir.
Very good, thank you. Legal, I'll wait till we go back into session.
Okay, any other questions for legal while we have her? Seeing none, we'll go back into session. All right, Representative Beck?
Thank you, and to the sponsor, there are certain ones on there I can see why you would not want to give up your ability to claim self-defense. But when you have a weapon on a property posted, no trespassing, or you're doing criminal trespassing, and there were a few others, why would we give them the ability, if you're criminally trespassing, or you've got a weapon on property that's posted no trespassing, why would we want to give them the ability to shoot somebody and then claim, oh, it's self-defense?
Thank you, Mr. Chairman. I don't believe we're giving someone the authority to shoot someone and then claim self-defense if it was not truly self-defense. But if you do find yourself trespassing and someone threatens you with bodily harm or death with another weapon, I think you still should be able to defend yourself. That's not what I wouldn't want to take someone's ability to defend themselves when they're only trespassing or only littering or only illegally parked. There are a number of things that this covers that in the Class B misdemeanors is why we left that out.
I agree with you with the parking, but I didn't hear that in the list. But the credit card fraud and buying somebody a lottery ticket and other things, I agree with you on. But I think you're throwing out some things. When I grew up on a farm and we had hunters come onto our property that was posted no trespassing, when you confront those hunters, it's just you, the hunter with the weapon, and this you know, he could say, oh, he was coming at me and I was in fear for my life, so I shot him dead, and now I'm claiming self-defense, even though I was violating the B misdemeanor. So I can't support that. I think if it was more narrow on the list, I could support it, but I can't support it as it comes today. So, but thank you.
Thank you, Mr. Chairman. I have personally experienced the exact situation you're talking about. When I was much younger, I had an individual that was trespassing that had 2 weapons on him. And fortunately, he didn't draw those or point them at me, but had he fired a shot, I would have certainly wanted to be able to defend myself. And I wasn't a trespasser in that situation. But by the same token, had I shot at him for no reason, which I could not lawfully shoot at him just because he's trespassing. That's not something that is a threat to my life or bodily harm. So I would not want him to give up his self-defense ability there to defend himself if I was doing something illegal. That's all this is doing, is protecting folks, the law-abiding citizens, again, if they're creating something or have an offense that's in this category of a Class B, that they still should be able to defend themselves.
Representative Beck.
I don't know if we got a misstatement there or not, but when you met that person, you weren't that was carrying guns. You were not trespassing. You were on your property. You met him or her at the while they were trespassing on your posted property, self-defense is available to you because you aren't committing any crime under this bill, but the person who's got the guns is committing a crime under a B misdemeanor, and we're going to give them out in the middle of nowhere the ability to shoot you and claim self-defense, basically, under this bill. So that's the reason I can't support it. But I thank you.
And all I'm saying is I would not have wanted to take that person's right, even though he was trespassing. That crime does not supersede, it doesn't rise to the level, and I think that's why it's in the Class B category. It doesn't rise to the level of a person giving up their right to defend themselves. If I had done something as the landowner, had done something offensive to him, like shoot at him for something that he should not have been shot at for, or to create that situation, I wouldn't want to take his defense away, is my opinion there.
What about criminal trespass, as she read? Why would we want to give somebody who is criminally trespassing the ability to kill someone and say, oh, I was scared they were coming at me. They came out of the shadows. They scared me. I was in fear for my life. And then they've got an absolute right to take them down.
And I don't know the difference, quite frankly, between criminal trespassing and trespassing. So that may be something that you could educate me on. I'm not sure the difference there.
Can we ask legal to define criminal trespassing, please?
Without objection, we'll go out of session. Hear from legal.
Michelle Fogarty, Legal Services. Criminal trespass. A person commits criminal trespass if the person enters or remains on property or any portion of property without the consent of the owner. Consent may be inferred in the case of property that is used for commercial activity available to the general public, or in the case of other property when the owner has communicated the owner's intent that the property be open to the general public.
Very good, thank you.
Any other questions for legal? Seeing none, we'll go back in session. Representative Beck, do you have any other comments?
No, but thank you, Mr. Chairman.
Thank you. Next on our list is Chairman Curcio.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing the bill. I think I was involved in at least one of the conversations that you're referencing where the kind of genesis of this bill came from. And so I agree. I think it's something that needs to be defined and tightened. And, you know, one of the examples that was given under that list was, you know, leaving a fire near woodland unattended. So if I'm, you know, in that example, and this is not, I mean, I know it sounds like a silly road to go down, but this was exactly the type of thing that we were talking about in that conversation, which prompted this bill, is that if I'm, you know, building a campfire and someone begins to attack me or comes near me to threaten me and I have to defend myself and I leave that, then technically at that point I am not able to apprise myself of that self-defense defense. So I know it sounds like we're cherry picking there, but that's exactly the point, is that you don't want somebody to lose their right to defend themselves because they are doing something, you know, minor. So I appreciate the spirit of the bill, and like I said, was involved in those initial conversations. So I appreciate you bringing this today.
Thank you. And one of the examples that our expert in legal gave me when he first brought this was, if a gentleman was driving down the road and his pregnant wife called him and he didn't want to be driving, if he didn't have a hands-free device, he wants to pull off the side of the road to take that phone call. When he's illegally parked and someone walks up to him to, let's say, hijack him and carjack him, if he shot them or shot at them or pulled a pistol on them, he legally was in violation of this law right now as it stands because he was illegally parked. He was involved in unlawful activity. That's all we're trying to correct here. So thank you for that.
Leader Lamberth.
Thank you to my friend from Davidson County. Thankfully, in the law, you can't shoot somebody for trespassing. And so if in this state, trespassing is a minor crime. It's something that, you know, usually carries a C or a B misdemeanor. There is an A misdemeanor version that this bill would not affect. But if you happen to wander out on somebody else's property and you miss the no trespassing sign, they can't come at you and threaten serious bodily injury or death to you. And if they do, you can defend yourself. That's exactly what this bill says. It just says if you're committing a very minor crime like trespassing and someone tries to kill you, you can defend yourself. And then everything else that was mentioned in the back and forth a while ago, with all due respect, I mean, is something for a jury to determine. This puts it in the jury's hands. I mean, it doesn't say it's automatic. It just says that you can at least make a self-defense argument. And then if the jury believes factually that that's what occurred, then, you're not guilty of that. But right now, the way the law stands, if you're committed even the tiniest of misdemeanors, you can't even assert self-defense, exactly as the chairman gave us an example a while ago, and was the list given by legal. So, I mean, it seems to me to be a significant step forward in the law so that we don't allow a minor misdemeanor to preclude someone from literally saving their own life. So I appreciate you bringing the bill, certainly support it.
Thank you, Leader Lambert, and thank you to my friend from Davidson County. That's what the subcommittee's for, is to vet these things out and make sure it's a good bill before it goes on, and I appreciate that. I know that you always look for those situations that someone else may have missed, and that's what we want. That's what this process is for, so I do appreciate that.
Any other questions for the sponsor? Seeing none, question has been called. Any objection? Seeing none, we're now voting on sending House Bill 26 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Your bill moves on to full criminal. If you wish to be recorded as a no, please see the clerk. Next item on the calendar, House Bill 1338 by Chairman Todd, be item number 12. What did I say? I'm sorry, thank you. House Bill 1388 by Chairman Todd. We have a motion. And a motion and a second. You're recognized.
Thank you, Mr. Chairman, and there is an amendment on this bill, drafting code 4096, that makes the bill.
All right, need a motion and a second. A motion and a second on the amendment. Go ahead.
Thank you, sir. This deals with section 3917-1307 in our code, which defines the offense of carrying a club or firearm. As many of you have heard me talk about recently with other bills, we in this country have the God-given right to protect ourselves, to keep and bear arms. Our government, by our Constitution, is not able to infringe on those rights. And those rights are, as I said, given by God. There are several enumerated in the Constitution. There are several that are not. But it's not an exclusive list. This is one of them that is enumerated. Over the years, many of us in many states have infringed on those rights. Our federal government has infringed on those rights. This is an attempt to clean that up, to get some of those infringements off, as we have done already in legislation this week. The permit system we have for carrying firearms, and also the new permitless system, the permitless carry that we passed a couple of nights ago, are only exceptions to punishment. Many of you know that. They don't actually remove the offense of carrying a club like a baseball bat or a firearm. What this bill does actually does that. It removes the offense. And I've been involved in this kind of discussion for many years about how to remove these infringements from our rights, and was actually surprised to learn that our permit system is only an exception. It does not say it's not an offense anymore. It just says you're not going to be punished for it. You can still be arrested with your permit for carrying and spend the night in jail and have to hire an attorney. That isn't done, fortunately, but that is the way our law is written, is that you still have to present a defense if you're arrested. The law gives you that defense if you have a permit, and now once the governor signs the bill into law that we passed a couple of nights ago, under those circumstances you could carry without a permit. But it's still only a defense, as you may remember the wording of the bill. So what this does, this removes that offense once and for all, except in certain situations. And the whole list, if you read the bill, the whole list of things is in there that a person qualifies for that would not be able to carry. Section 3917-1308 states that it is a defense when arrested or confronted for carrying. So this bill actually deletes 1308. Once we make this change, we would not need that section any longer. It removes the criminal aspect that was put into code as an infringement on our rights. That's simply what this does. I would be glad to take any questions.
Thank you. Any questions for our sponsor on the amendment? Chairman Curcio.
Thank you, Mr. Chairman, and thank you, Representative, for bringing the bill. Just looking at the code section that we're dealing in, and this may be your intent. I'm sorry I didn't get a chance to ask you this before committee. But if we were to pass this and be signed into law, it's my understanding that we would be deleting the code section that we just amended with the governor's permitless carry bill. Is that your understanding?
Mr. Chairman, I believe that is the case. I have not had that discussion with legal at this point, knowing what position that is in compared to what position this is in. And I think that they still would go hand in hand. I don't think it would change the outcome from the standpoint of the purpose of that bill that we just passed. Now, I'm open to legal's interpretation of that. Again, with the pace that we've had since night before last, there's just not been an opportunity to clarify that.
Thank you, Mr. Chairman. I would certainly defer to legal, but it's my understanding that if these two were to pass, what you would be left with was all of the enhancements in the governor's permitless carry bill, but the first section of that bill would be rewritten by this. So basically, this version of permitless carry with the governor's desires on enhancements. I think that's right. Again, I don't know if that was your intent, may have been your intent, but I just wanted to.
I believe that is correct, and that would be, yeah, that would certainly be my intent.
Thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Any other questions? Representative Beck.
To the sponsor, removing this part of the code and this penalty, how would that affect the laws of where you're not to carry? Private businesses, posting, etc. If there's no penalty, seems to me you could carry anywhere. Am I mistaken?
Thank you, Mr. Chairman. It still would not affect property rights. Those are still protected by law. That it doesn't say you can violate someone's wishes on their own property.
Is that a separate penal code, or seems to me it all grows out of the same section, and we may need to go out of session to ask legal, Mr. Chairman.
All right. Without objection, we'll go out of session and hear from legal.
Michelle Fogarty, Legal Services. Could you repeat the question, please?
Yes, by removing the penalty from this, removing this whole section that has to do with penalty for wrongfully carrying a firearm, how does that affect penalties for having a firearm where it's posted you should not have a firearm?
I believe those would remain in effect because they are posted. And I also believe that all the rights that a permit holder has would remain in effect. But I will double check on that. Does that answer your question?
Sort of, but we're not sure on either one of those bases at this point. I mean we're just asking you to do it on the fly, but.
This bill does not affect enhanced handgun carry permit holders and the rights that they have as a result of that enhanced handgun carry permit.
Now that's the enhanced carry permit.
Correct.
Okay. All right, so if this bill passes and becomes law, it's not going to affect where you can carry, and it's not going to affect the bill that was passed on Monday night. Is that correct?
It will affect, it does not work with the governors, with what was passed on Monday night. They don't work together. The language of this amendment deletes and rewrites section 3917-1307.
So if we pass this, it's in conflict with Leader Lambert's bill that he partially passed on Monday, is that correct?
They do not work together.
Okay, thank you.
Any other questions for legal? Leader Lambert.
Mr. Chairman, since my name was called, just a follow-up question for legal. I think what you mean by that is that, as the sponsor has described, the bill that was passed on Monday night, which again was a phenomenal bill and a great step forward, appreciate everybody's support for it, is an exception to the current carry statute. This would remove all of that and rewrite the entire section. That's what you mean by they're in conflict with each other.
Yes,
It's a different perspective on how to go about that.
Yes, sir, that's correct.
All right, thank you.
Any other questions? Seeing none, we'll go back into session. Any other questions for the sponsor on this? We are still on the amendment. Chairman Curcio.
Thank you, Mr. Chairman. So, and I appreciated that back and forth. So there were several amendments on the floor Monday night that would change the way the governor dealt with the permitless carry. Was this one of those options that was discussed in those amendments?
No, sir.
Okay. But it is a different version. It could well have been an amendment to that bill. Is that?
It could have been. I actually drafted this as an amendment to that bill a few weeks ago, but decided that wasn't really the right way to go about it. I think, as she stated, the enhancements will not be effective whatsoever, so we still get the increased penalties for gun crimes, which I think is a really good step. We need that. I was quite appalled to find out how little punishment there is for a gun crime in certain ones, but this would, again, go at a different angle from the standpoint of the permitless carry, where that bill that we passed, as well as our enhanced permit, only gives us a defense to a criminal offense that we're trying to correct here. This is taking the offense away, once and for all.
Okay. Thank you very much for that explanation. So again, this would just be a way to kind of do it, your way as opposed to the governor's way.
Yes, sir. And when I started looking into this, not only what the governor had proposed, but what we've done in the past, I was very surprised that we're going about it in this manner. Why are we giving an exception to an offense and just creating a defense for it instead of removing the offense as we should have? I still don't know how we got there. I don't know how over the years that's been the tradition, but it has been. I'm not really sure why. Instead of going and correcting this, that went on in the late 1800s after the Civil War, for reasons that I don't think any of us would appreciate. But they were very bad reasons, and that's how this actually got created. And we've nibbled at it and worked around the defense side of it instead of dealing with the offense. And so that's all this does.
Thank you very much.
Leader Lambert.
Thank you, Mr. Chairman, and I only wanted to thank the sponsor of the bill for actually going through the committee system. I know that, anybody can file any amendment they want to on the floor, but you had a different way to do this, a different idea about it, and you're going through the proper system instead of trying to, quite frankly, as we've seen a couple times over the years, just try to hijack a bill that's on the floor because it happens to deal with a subject matter that you're passionate about, and that, having a separate bill on this, I think is a much better way to go about it. And so, again, I appreciate you working through the committee system. It's just a different way to look at this issue. I mean, it's a completely new way. And I appreciate you working with Chairman Curcio and others to really kind of look at, hey, why is a defense instead of just starting from scratch and kind of rebuilding the statute? It's a much heavier lift. But again, appreciate you going through the committee system and doing it that way instead of just, filing an amendment on the floor that had not been through the committee system. Thank you.
Thank you for saying that, and I have worked with a number of members, including Judge Carter. I wish he was here with us right now, but he has been instrumental in this as well. And I think this really, I want to remind the committee, as I have in other committees, that when other bills were presented, that we have an oath to uphold the Constitution, and that Constitution says that right that we already have given by God shall not be infringed. This is an infringement that we have discovered that needs to be removed. So I think it's our duty to uphold our oath to remove this infringement. Thank you, Mr. Chairman.
Representative Beck.
Thank you, Mr. Chairman. And it just hit me that if we rewrite this section, there will be no penalty for taking out any weapon, whether it's an AR-15 or long gun, rifle, and walk down Broadway with any of those under this bill. Is that correct?
I believe it would be, sir. As our Constitution states, keep and bear arms, not handguns, arms.
Very good.
Any other questions for the sponsor? Question has been called on the amendment. Any objection? Seeing none, we're now voting on adding amendment number 004096 on the House Bill 1388. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're now on House Bill 1388 as amended. Any questions for the sponsor? Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1388 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full criminal. Thank you.
Mr. Chairman and Committee.
If you wish to be recorded as a no, please see the clerk. Item number 13, House Bill 427 by Chairlady Littleton. Second. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. This bill says the parties with which a victim of sexual battery is incapable of consenting to sexual contact with is a member of the clergy, healthcare professional, or an alcohol and drug abuser counselor who was treated the victim for mental, emotional, or physical condition.
Okay, there's an amendment on this. Do you
I'm sorry, that was the amendment makes the bill.
Okay, you have a motion and a second on amendment coded 006145. Those in favor of the amendment say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We are on House Bill 427 as amended.
The amendment made the bill.
The amendment made the bill. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 427 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Move on to full criminal. Thank you. Next item, number 14, Chairlady Littleton, House Bill 951. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. This was brought to me last year by the DAs, and I got caught up in the COVID, so here we are again with the bill. It creates a Class A misdemeanor offense of negligently, by act of omission, engaging in conduct that places a child in imminent danger or death, bodily injury, or physical or mental impairment, creates a D felony offense of negligently, I cannot talk today, by act or omission engaging in the conduct that places a child that is 8 years of age or less in imminent danger of death, bodily injury, or physical or mental impairment.
Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 951 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full. Thank you. Item 15, House Bill 955. Chairlady Littleton. Motion second. Motion second. Recognized.
Thank you, Mr. Chairman. This does have an amendment that makes the bill. It's 4606.
Amendment number 4606. We have a motion and a second. You are recognized on that amendment.
Thank you, Mr. Chairman. This bill states that should a juvenile adjudicated delinquent commit conduct that, if committed by an adult, would constitute an offense of aggravated rape, rape of a child, or aggravated rape of a child, the court shall instruct the child that he or she must not accept employment or volunteer in any capacity that the child knows or reasonably should know will cause the child to be in close and frequent contact with the minor.
Thank you. Any questions for our sponsor on the amendment? Question's been called on the amendment. Any objection? Seeing none, we're now voting to adopt Amendment Code 004606 on the House Bill 955. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We adopt. We're on House Bill 955 as amended.
The amendment makes the bill.
Thank you very much. Any other questions? Question's been called. Any objections? Seeing none, we're now voting on sending House Bill 955 on the full criminal as amended. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We move on. Thank you.
Thank you, Mr. Chairman and
Thank
committee.
you. Item number 16, House Bill 1143. We have a motion and a second. Vice Chairman Grills.
Thank you, Mr. Chairman.
You are recognized.
Thank you, Mr. Chairman. I'm hoping somebody's going to call a question on the bill before I got up here. Not so lucky today, am I? This bill was given to me by Senator Rose. He had some constituents in his district that had children that were hurt by individuals driving on a revoked license. And so ultimately what this bill does, it seeks to put some more teeth into the drivers who are repeatedly caught without driving on revoked or suspended license. Currently, the first offense is a Class B misdemeanor, and the second subsequent offenses are Class A misdemeanors. So ultimately what this bill is going to do is change the third offense to a Class E felony.
Any questions for our sponsor?
Oh, man, I've already put myself in the position, haven't I?
Leader Lamberth.
Thank you, Mr. Chairman. Given the introductory remarks, we were seriously considering rolling this bill to the hill, but I'll wait. I'll wait until others have asked questions of the bill before we make that determination.
I love you, William.
Without objection, we're going to roll 2 spaces. That will bring us back up to item number 2, House Bill 1430 by Chair Lady Moody. So you have a motion and a second. You're recognized.
Thank you, committee and Mr. Chairman. This bill I'm bringing today, and it does have an amendment.
Amendment Code 005557.
Correct.
All right, you recognized on the amendment?
Thank you very much. The amendment does make the bill, and just the short version of this is the legislation will broaden the definition of bodily injury as it pertains to domestic abuse. And it adds to 3911-106, which is the title regarding criminal offenses, specifically title definitions. And again, it broadens the definition of serious bodily injury to include a specific reference to instances of domestic abuse. And those additions include a broken bone regardless of the victim's age, damage to the palate or other sensory function, including but not limited to the ears, mouth, eyes, or nose that requires medical repair or reconstruction, tearing of ligaments or muscle tissue, dislocation of joints, abrasions to the neck, face, or chest, substantial bruising to the body, and I'll stop there.
Thank you. Any questions for the sponsor on the amendment? Leader Lamberth.
I just want to make sure I understand the amendment, and I know you're subbing in for another sponsor, but in essence, will this make every domestic assault case a felony?
Give me a second. You know, I don't know if I can answer that.
Mr. Chairman, could we go out of session to legal? Domestic assault is a very broad definition, includes many different types of actions. I'm trying to determine in the amendment if it is those domestic assaults in which there is any injury whatsoever that we are now presuming that to be serious bodily injury, thus making all of those domestic assaults a felony. I just want to make sure that the intent of the bill is out there if that's what it is. Mr. Chairman, may we ask that question to legal?
Yes, without objection, we'll go out of session, hear from legal.
Could you specifically restate your question?
If you can, just give us a brief, just kind of legal definition of what we are changing in the law here. It appears, again, that we are making, if not all, virtually all domestic assault misdemeanors now felonies in which there is any bodily injury whatsoever. I'm just curious if that is what the language does. It's what it reads like, but I wanted to make sure.
Well, Michelle Fogarty, Legal Services. The language in the amendment changes the definition of serious bodily injury. So any offense in this title that references serious bodily injury, if it involves a domestic assault victim, then the definition in this amendment is going to apply. So it will be any broken bone, the tearing of ligaments, muscle tissue, abrasions to the neck, face, or chest, substantial bruising to the body, or dislocation of joints. That's going to be, any of those injuries are going to be considered to be serious bodily injury under this definition. So any time that term is referenced in this title, then that definition is going to apply if the victim is a domestic assault victim.
All of those under current law are serious bodily injury, though. I mean, that we added strangulation, we added several others within the domestic violence definition. That's what I'm trying to understand, the distinction of what we are changing here. It has a fiscal note of about $14.6 million. So again, I was trying to make the fiscal note and the language of the amendment comply with one another. It appeared that it did the opposite of what you're describing. I'm just trying to figure that out because it seemed like it made any injury serious bodily injury, but it may not do that. But the fiscal note obviously makes some assumptions there that we're greatly expanding, and I'm not arguing the merits one way or the other right now. I'm just trying to figure out exactly what the distinction is we're drawing.
I can't speak to the intent, but I know there are the term serious bodily injury is referenced numerous times in Title 39. So anytime there is an offense for punishment that involves serious bodily injury, if the victim is a domestic assault victim, then this definition is going to apply, and that could possibly raise the level of the offense.
Any other questions for legal? Seeing none, we'll go back and, I'm sorry, Representative Russell.
Thank you, Chairman. Just a question for legal about assault with serious bodily injury. What's the classification code for the felony now compared to what the classification for the felony would be if it's under domestic violence?
Are you talking about domestic assault or just regular assault? Aggravated
The
assault?
domestic abuse assault under this new amendment, what would the classification code be for the class of felony? It would be under serious bodily injury. Is that different from seriously bodily injury for assault now?
The language of this amendment doesn't change the offense of domestic assault, the punishment. It just changes what is defined as serious bodily injury.
Okay, thank you.
Any other questions for legal? Seeing none, we'll go back in session. Chair Lady Moody.
I'm trying to determine if I feel a cool breeze, and I see a no. Well, I want, since it's not my bill, and I feel honored to carry it.
Are
certainly.
you asking to roll it a week?
Yes, I think so.
Okay. Any objection, we'll roll House Bill 1431 week.
Thank you.
Brings us up to item number 8, House Bill 109 by Chairman Hulsey.
Thank you, Mr. Chairman.
Amendment Code 006318. You recognized on the amendment.
That is correct, and if I can ask your indulgence for a verbal amendment that's doesn't have much substance to it at all. The parole board asked that we change the start date to July 1st, and I'm asking if that's a simple enough amendment that you could orally put that on.
Thank you, Mr. Chairman. Mr. Chairman, it's my understanding that members of the committee are able to make verbal amendments, and pursuant to that, I wish to make a verbal amendment that we change the start date to July 1st.
Motion and second. Any objection? We'll now vote to add that verbal amendment to July 1st. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. All right, we adopt. We're now on Amendment 1 as amended. Chairman Halsey, you are recognized.
Thank you, 6318. And what it does is the district attorneys were asking for TUMS on my first bill, and they didn't like the word presumption, so it was rewritten to use the word consider, that the parole board would consider. This bill deals with people that are in our institutions, our penitentiaries, who have been charged in the state court, but they've been also charged many times for the same crime in federal court and been found guilty. And they're serving time in our penitentiaries, but they're waiting when they get out of our penitentiary to go to a federal penitentiary. 99% of them, these are federal warrants, to go to a federal penitentiary and serve another sentence. This bill says that we're trying to save Tennessee taxpayers a lot of money here. It says if you're eligible for parole in Tennessee and you got more time to serve in the federal penitentiary than you got left in the state penitentiary, then this bill says the parole board will consider running them out to the state penitentiary and let the federal government pay it. And that's what the bill says.
Any other questions for the sponsor? We are on the amendment. We need to. So questions been called on the amendment. Any objections? Seeing none, we're now voting to add amendment number 1 as amended on the House Bill 109. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We are now back on House Bill 109 as amended.
I don't think I can bloviate anymore. That's all I got.
All right. Any other questions? Chairman Curcio.
Thank you, Mr. Chairman. I move previous question.
Question has been called. Any objection? Seeing none, we're now voting to send House Bill 109 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on.
Members, that brings us to item number 16 on your calendar, House Bill 1143, which was previously considered and rolled 2 spaces. Representative Grills, you are recognized.
Thank you, Mr. Chairman. It's good to see you have the gavel now.
I'll do my best.
I tell you,
Yes, sir.
after a conversation we had a couple of minutes ago about some different things, let's roll this bill to next week, if that'd be okay with you and the committee.
Without objection, sir, rolled 1 week.
And I'm going to go talk to Chairman Doggett right now. Thank you.
Sir. Thank you. Members, that brings us to item number 17, House Bill 924 by Representative Wright. Sir, you have a motion and a second. And while things are being prepared, I see you also have an amendment coded 6057. Do you wish to move that amendment today?
Thank you, Mr. Chairman and committee. I have to throw myself on the mercy of the court in that the Senate moved out 6228, which is the same amendment, but it adds a comma of the third line after the word property.
Representative Wright, it's my understanding that
Could I ask for a verbal amendment to add a comma after the word property and use 6228?
Chairman Howell, you're recognized.
Thank you, Mr. Chairman. I make a verbal amendment, motion for a verbal amendment to do what Chairman Wright said.
You have a motion and a second on a verbal amendment. Committee, is there any discussion? Seeing none, All those in favor of adopting the verbal amendment moved by Chairman Howell, please signify by saying aye. Those opposed, you adopt. We are now on Amendment 1 as amended. And I need a motion and a second on Amendment 1 as amended. Thank you, sir. Thank you, committee. Sir, you're recognized on amendment coded 6057 as amended.
Thank you, Mr. Chairman, for allowing me to be in proper form. Now I want to go out of form for just a second and say this bill makes me the draft drone king, and that last year I had a bill, football team didn't want flyers being released from a drone which would drift over their games. Later on, an event promoter did not want people filming from a drone. So today what I'm doing is expanding some drone work, use of law enforcement to make us safer in the state of Tennessee. Currently in code, there is the allowance for the use of a drone, and there are 7 defined uses that a drone may be used by law enforcement. What I'm attempting with this bill is to add 3 more uses of a drone, 1 being used at a crime scene, 2 in the event of a natural disaster declared state of emergency, and 3rd, with consent at a large public event. This bill has been amended to also change the date of the retention of information from 3 days to 15 days. And then if we do not like the bill at some future date, it now has, as a part of the amended version, a sunshine date of July the 1st, 2024. And with that, I stand for questions. Thank you, Mr. Chairman.
Thank you, Mr. Sponsor. After conferring with legal, I do want to just advise you for full disclosure. Doesn't mean you have to do anything with this information. If it was your intent for that verbal amendment to match up with what the Senate adopted, we did not accomplish that. So the Senate amendment changed a lot more than that comma.
Then the amendment that we amended, there are 3 amendments. The second amendment should look like the Senate.
No, sir. We only have 1 amendment that was filed with this committee. I'm not trying to knock you off your game here at all. I just, again, you previously stated on the record that it was your desire and your thought that 1 comma would put you in syncopation with the other body down the hall, and that was insufficient to do that. If you wish to proceed forward, you're certainly welcome to do that. This body often does things differently than the other body. But if you're trying to be in the same posture as the Senate, I just want you to know that you're not. So if you want to, I want you to do what you want to do with your bill. But if you want to roll a week and get in the exact same posture as the Senate, that's up to you. If you want to continue forward the way this is, it's totally up to you. But I just did want to advise you that did not make it match the Senate.
Right. If this committee will allow me to roll the 1 week, I will accept a roll.
Yes, sir. I'm also, and just to advise you, if we roll this, because of the number of times it's been calendared, it will go to the special calendar. That's not a problem. It will be taken up on that special calendar. You'll still have an option there to move it forward. I just, again, want to advise you of that as well.
Okay. Thanks for the advice. I will be taken up by this committee at some point in time in this session.
Yes, sir. The special calendar will be taken up after the final calendar. Okay. But it will be taken up and be taken just as seriously as the rest of our calendars for the year. Did that answer your question?
That most certainly did, and
All
I
right.
appreciate the indulgence.
Yes, sir.
This has created more paperwork than I've carried around on anything else.
I completely understand, and that's why I want to make sure you totally understand that you understand what posture you're in, and that we don't have any misunderstandings. I do have Chairman Howell on the list. Chairman Howell, you recognized?
Thank you, Mr. Chairman. I was just going to suggest to the sponsor, another option would be to let the Senate pass it, and you can just consent and conform on the floor, and we can move forward. But that's your decision. Thank you, Mr. Chairman.
Let me again say that I would go with the guidance of the committee and with the chairman, and I agree with the chairman. Thank you.
Thank you, sir. Without objection, then, this will be rolled to the special calendar.
Thanks.
Members, that brings us to item number 18 by Representative Lynn. I do not see her in the room. That will be rolled to the heel. Next, that brings us to item number 20, House Bill 997 by Leader Love. I do not see Leader Love in the room. That objection rolled to the heel. Members, that brings us to item number 21, House Bill 1480 by Vice Chairman Parkinson. Vice Chairman Parkinson, you're recognized on House Bill 1480.
Thank you, Mr. Chair, and thank you, committee. If we can, hopefully we can get a motion and a second on the bill to get the amendment on.
Motion.
Thank you. Thank you, Mr. Chair, and if we can entertain a motion for it. Not trying to run your committee, Mr. Chair. Just
So, Representative Parkinson, there is an amendment filed with the committee. It's coded 5926. Do you wish to move that amendment?
Yes, sir. Yes, sir.
Okay. The posture we find ourselves is Representative Parkinson moves Amendment 5926. Do we have a motion? And a second? Okay, we have a motion and a second. We're on the amendment, sir.
Thank you, Mr. Chair. An amendment actually rewrites the bill. And out of transparency, members, I just want to get the amendments on and discuss the bill and then hold it here to next week because I'm speaking to the DAs and I think hopefully they'll be okay with it. It seemed like they were leaning that way. Listen, because this bill is important to me and I want everyone, all stakeholders to at least be okay with the bill, if that's okay. So if you don't mind, Mr. Chair, I'll discuss the bill.
Representative Parkinson, the parliamentary situation we find ourselves in is you have a motion and a second on amendment coded 5926, which is my understanding that rewrites the bill.
Yes, sir.
If you would like to get that amendment on the bill, is that what I'm hearing?
Yes, sir.
All right, so all those in favor of attaching amendment coded 5926 to House Bill 1480, please signify by saying aye. Those opposed? You adopt. We're now on House Bill 1480 as amended.
Thank you, Mr. Chair and committee. Currently, state law says anyone in possession of marijuana in amounts between 1/2 ounce and 10 pounds, it may be inferred that you are in possession with the intent to sell, manufacture, and distribute. It may be inferred. The wording may be inferred in the code allows for different outcomes in different courts and laws and jurisdictions. Let me give you an example. Let's say in Tipton County, an individual is found in possession of 3/4 of an ounce. They may receive a felony charge because the inference can be put in based on that weight. Let's say, on the other hand, an individual is found in possession of 3/4 of an ounce in Shelby County. In Shelby County, that inference may not be applied just because they don't want to apply it, because they don't want to deal with small amounts. But what we would end up having is, in different parts of the state, different individuals being charged differently, and possibly the inference being applied in some places and the inference not being applied in other places. What I'm doing with this bill is I'm creating a uniform standard in code regarding simple possession, ensuring that all members of this committee, I want to ensure that all members of this committee understand that we are not legalizing marijuana or decriminalizing marijuana. This bill changes and specifies how and when felony inference is applied. And let's think about this, members. For basically a $60 crime, the state is paying $85 a day to house or incarcerate these individuals, or somewhere around that space. This bill also creates an annual savings to the state of more than $300,000. And even charging a citizen in our state with a felony, whether the final outcome is a felony or reduced down to a misdemeanor, the fact that you were charged with a felony has consequences also. So again, what we're doing with this bill is clarifying in the code that the inference will be applied if there's evidence of manufacturing, distributing, or selling in amounts of less than 1 ounce of leafy marijuana only. And just real quick, I just want to point out a couple of things in the bill itself, in the amendment itself. Number one, it is an offense for a person to sell or distribute marijuana in an amount less than 1 ounce. It's still criminal. Number two, it is an offense for a person to knowingly possess or casually exchange marijuana in an amount of less than 1 ounce. It's still criminal. Under A, casually exchange, this is language that I got as an amendment from our leader, from Leader Lambert, when I ran the bill a few years ago, and we wanted to make sure that that was clarified in there. So we kept the same language from Leader Lambert's amendment. Section 3, I want to go to 4B, and this right here to me is the meat of the legislation. The intent to sell or otherwise dispense shall not be inferred solely from the possession or casual exchange of less than 1 ounce of marijuana. However, key sentence, however, other relevant facts surrounding the arrest may be used to infer such an intent. And what that means is, to me, is if the evidence is there, stick it to them. If the evidence is not present, let's not apply felonies to people who don't deserve to be charged with a felony. And that's what the bill does.
Thank you, Mr. Sponsor, for that explanation. Members, do we have any questions for the sponsor of the legislation as amended? Chairman Howell, you're recognized.
Thank you, Mr. Chairman. And to the sponsor, thank you for coming by and visiting with me about this. And it occurred to me as I was looking at your bill that it seems like this bill is really a truth in sentencing.
Yes, sir.
Bill.
That's exactly what it is. Truth in sentencing and truth in
Representative
charging.
Parkinson, you're recognized.
I'm sorry, Mr. Chair. Truth in sentencing and truth in charging, because based on the language now, a lot of people that may have simple possession or possession under 1 ounce are charged with the felony. It may not come out in the wash as a felony at the end of it, but the charge of a felony is an issue also. And this will clarify, so we're uniform across the state in how this is applied.
Chairman Howell.
Thank you, Mr. Chairman. And so your example that you used in Tipton County versus Shelby County, you're seeking to standardize the sentencing guidelines for the entire state of Tennessee, where now it is not standardized? Am I on the right track here?
Representative Parkinson.
Thank you, Mr. Chair. Yes, and not only that, but seeking to standardize the application, how the inference is applied across the state. Yes, sir.
Thank you, Mr. Chairman.
Thank you, Chairman Howell. Any further follow-up? Okay. Members, any other questions for the sponsor of the legislation? Seeing none, we're ready to vote. All those in favor of sending House Bill 1480 as amended to criminal full, please signify by saying aye. Aye. Those opposed? No. The ayes have it, sir. You head to criminal full.
Thank you, Mr. Chair. And thank you, committee.
Thank you, Representative Parkinson. I will hand the gavel back to our chairman.
We're on item number 22, House Bill 1493. Representative Towns. None in the room. We will roll this to the heel of the calendar. Item number 23, House Bill 592 by Representative Clemens. We'll roll to the heel. Item number 24, House Bill 457 by Representative Thompson has been taken off notice. Item 25, House Bill 1459 by Representative Hakeem. We'll need a motion in a second on that, please. Motion. You're recognized.
Thank you very much, Mr. Chairman and members. What this bill is about is nationally, in the past, the state of Tennessee has been ranked number 4 in regards to deaths after domestic assaults in a home. Now we're number 9. And I think we want to continue on the path of being further down the line on that number. And the pandemic, I think, has exacerbated the problem of people having increased domestic assaults and so forth. And what we're trying to do is to create more of a cooling off period between the incident and the person who is the perpetrator going back into, we'll say, the home. And what this bill does is require a magistrate to order, as a condition of release or bail, a person arrested for domestic assault to vacate or stay away from the place where the victim resides for 24 hours. Presently, my understanding is it's 8 hours, and we're saying 24 hours. The intent is to afford an opportunity for a cooling off period to take place, and if someone has a substance in their system, more of a time for that to dissipate. And we would add that present law says that if that person goes back to that residence prior to that time period, they can be arrested without a warrant or with a warrant. So essentially what we're doing is trying to provide an opportunity for a cooling off period and for there hopefully to be a lessening of events that take place where death is the result of a domestic assault. Thank you, Mr. Chairman.
Thank you. Any questions for the sponsor, Representative Beck?
Thank you, Mr. Chairman. To the sponsor, so is this a mandatory cooling off period? I mean, there's no discretion by the judge, even if somebody would lose their job or et cetera. I mean, there's no discretion by the judge. Is this totally mandatory?
As it is written, the magistrate, as it is written, yes, sir, that would be mandatory. Go ahead. I'm sorry.
It's just, I understand the magistrate's not the judge, but it's still, it's hard to say, and I appreciate the spirit of the bill. I think it's very, very well taken, but to say it's mandatory, I'd have to think about that. But I appreciate the spirit of the bill, and I appreciate you bringing the bill. I'm usually against, no matter in what bill, if it's takes the judge's discretion, but it is the magistrate in this particular instance. But I'll let my other members ask questions, but I thank you.
Yes, sir.
Leader Lambert.
Thank you, Mr. Chairman, and I join my friend from Davidson County in the comments that, I mean, we allowed discretion in all of these instances because we are not the judge or the magistrate that's in that room with the individual who's evaluating these factors to determine what's in the best interest of both the victim, but also that preserves the rights of the defendant in that instance. So the fact that this has, I mean, shall, even in the 12-hour hold that you mentioned, not 8, but it's a 12-hour hold right now, helped draft that many years ago, and there are some exceptions even to that,
yes,
where the judge can take those into account. There's also, I mean, a magistrate already can put a no contact order on a bond. The victim can get an order of protection. We've beefed a lot of that up in the last few years. again, I share my colleagues' statements that, I mean, your intentions here are absolutely pure. You're trying to do a very good thing. It just seems like it needs quite a bit more work. As written, it, again, has some issues. Let me ask this. What would your preference be to either do a summer study on this or something else? I mean, I just feel like you need to speak directly with some of these magistrates, talk with the judges, meet with some of the district attorneys that are prosecuting these cases, some of the victim advocacy groups out there. I think there's probably a better way to get to where you would like to go. But do you have a preference as to what direction you might take on that? Because it just seems like it needs some additional work.
Thank you, Mr. Chairman. I'm at the pleasure of the committee. Now, what I'm getting at is if it's more acceptable or feasible, you know, we can go from, I guess, from shall to, what is it? Leaving more, giving more discretion to the judge or magistrate. If that's not something that we could consider in this session, then I guess I would have to look at summer study or something of that nature.
Okay. Well, with that, I mean, if you're fine with it, because I think that, you know, it's an opportunity here to really, and I hope, and I know our full committee chairman is looking diligently down there. I mean, I hope that the speaker and our chairman will do a full summer study on a variety of issues. I quite frankly think that bond and bail conditions and how we make sure that victims are protected while the case is moving through the system and the defendant's rights are protected because they're innocent until proven guilty is a really good conversation for a summer study. So when I make this motion, understand that I want you to actually get that opportunity. I don't want this type of bill to just go into a summer study and not get the discussion it deserves.
Yes,
so I say that in hopes that this will occur. So with that, I would make a motion to send this to summer study.
The motion, second on that is a proper motion. Seconded. Any objection? Seeing none, and we're now voting to send House Bill 1459 to summer study. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. Goes to summer study.
Thank you, Chairman and members.
Thank you. Members, let's go back to item number 22, House Bill 1493 by Representative Towns. That's you. Motion. There's a motion, a second. You are recognized, Representative.
Mr. Chairman, members, thank you very much. You're very kind. I thought you said something else about me. Mr. Chairman, members, I'd like to explain what's going on, and I'm going to ask for your indulgence and also ask that we assist in this particular bill. I don't know how many of y'all are familiar with Kratom, okay, and what it really does. You know, we have an opioid crisis in our country, and Kratom is used to help people stay off opioids. It's really good, as my research has taught me. It actually helps people to get off opioids. So what you have is something that's powerful, you want not to hurt it at all. And what we were trying to do based upon what has happened with pharmacists that have come to us, they want to try to regulate themselves a little bit better because anything can be dangerous, okay? And so I had a group of pharmacists come to me and ask me, see if we could do legislation that would allow it to be sold in smaller quantities, retail. In other words, if I come to the store and I buy it, reduce it down to a certain amount of ounces. Because what people were doing is buying it in bulk for resale, and they're not pharmacists and they're not herbalists and so forth. So they asked me to do it, and I thought it was a good idea. However, what I'd like to do is this, because I've had some calls that were positive in that direction. But because of the complications seemingly I'm having with the Senate to understand what's totally going on, I'd like to see if we can probably put it in the summer study and study it a little bit, if you don't mind. Okay, I'm going to bring it back next year, but I'd like to get a little bit more input in it, if you don't mind, Mr. Chairman.
Well, as a request, the committee, Leader Lamberth, you're recognized.
Okay.
Make a motion, summer study.
As motioned and seconded, I will say that I know that you have worked very hard on this. You and I have had many conversations about what's going on. Ms. Andrea has been working with us very diligently, trying to come to some kind of conclusion, and I know that sometimes there's always different directions that you go. We're all trying to achieve the same goal, but continuing the conversations in the summer, I think, is a great thing that we're going to do, and look forward to those. So there is a motion and a second for a summer study. Any objection? Seeing none, we're now voting to send House Bill 1493 on to summer study. All those in favor say aye. Aye. Those opposed? The ayes prevail. You go to summer study. Thank you. Item number 23, House Bill 592 by Representative Clemens.
Motion.
Bill fails for a lack of second.
Thank you.
Item number 26, House Bill 420 by Representative Harris.
Motion.
Item fails for a lack of second. Item number 27, House Bill 1102 by Representative Shaw. You have a motion and a second. You are properly recognized.
Thank you, Mr. Chairman and members. I have an amendment that makes this bill.
Amendment number 005820. Motion and second was on that. You are recognized on the amendment.
I'd like to explain this and what this amendment does in simple terms. It comes from TBI and the DA combined. They wrote this amendment for us to make the bill. And what the amendment simply says, the amendment specifies that domestic assaults which were created in 2000 will not be included in this bill. Only assaults after 2000 may be eligible for expungement. That is the amendment that makes the bill. I'm also at the will of this committee. I've spoken to both chairmen as well as some other members about this as to how we might be able to solve some problems for some of our constituents with old domestic assaults that's holding them back in many ways from getting their lives on. And so I'm kind of at the will of the committee at this point to answer any questions I can or accept any suggestions that you may have.
Thank you, Representative. Any questions for the sponsor on the amendment? Representative Lambert.
Thank you, Mr. Chairman. I mean, I just want to highlight, these are folks that would have been eligible for judicial diversion that either simply didn't have a lawyer that asked or did not ask themselves when they were found guilty of the crime. So we're not adding anybody to the list that is eligible, that was not otherwise eligible for diversion. Right. They simply just didn't get in on the front end, and under the law, they are ineligible on the back end. My only question is, why July 1st of 2000? It's 21 years ago. Obviously, these are folks, there are a lot of folks within that 21 years that potentially would be eligible for diversion. Is it just kind of you had to start somewhere, or why the July 1st, 2000?
I just kind of had to start where I could, Mr. Leader, but I'm at the will of the committee to accept the verbal amendment to move it up if that's possible, because we'd like to get everybody we possibly can that would be eligible for the expungement.
Members, we're going to go out of session and hear from legal on this.
Michelle Fogarty, Legal Services. The offense of domestic assault was enacted in 2000, which I believe is the reason for the date in this amendment.
Okay.
So
Any other
prior to that
questions?
date, I'm sorry.
I'm sorry.
Yeah. So prior to that date, there was no offense of domestic assault. It would have just been prosecuted as assault.
So domestic assault was not on the book, so to say, until 2000.
Correct.
Okay. Any other questions for legal? Seeing none, we'll go back into session. Leader Lambert, you recognize you have anything you'd like to say?
No, I just learned something new every day. I mean, Chairman Farmer and I were over here talking about this kind of off here and off the mics here. Both of us came on and started practicing law beyond 2000. And so I wasn't aware that that was why the date. So again, we've learned something today, and that's a good thing. So,
Thank you very much. Any other questions for the sponsor? We're still on the amendment. Seeing none, any objection to the question? Seeing none, we're now voting to add amendment number 005495 on the House Bill 1393. All those in favor say aye. Aye. I'm sorry, members. I looked at the wrong amendment code there and was adding it to the wrong bill. So if you will forgive me, let's rewind that back. We're voting to add amendment code 005820 on the House Bill 1102. All those in favor say aye. Those opposed, no. The ayes prevail. We are on House Bill 1102 as amended. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on House Bill 1102 as amended, sent on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We move on to full criminal. Thank you.
Thank you, Mr. Chairman.
Next item on the calendar, number 28, House Bill 1393 by Representative Shaw.
Motion.
You have a second?
I wanted to just suggest that the Senate sponsor wanted to roll this 1 week, if we could. I got a notice while I was sitting here. Of course, if it's cloudy, we'll just do what we need to do with it.
We'll roll it to our last calendar if that suits you.
Thank you.
Without objection, roll to the last calendar.
Thank you, Mr. Chairman and members.
Item number 31, House Bill 864 by Representative Chisholm.
Motion.
All right, you have a second there. You want to roll this 1 week?
yes.
Objection?
If we can, Chairman, we're getting bills that are kind of building up on the chairman's calendar. Would it be all right if the member would be okay with this, give you plenty of time to work it and not get into this situation where it's just on the calendar, and this is not just your bill, this is for several, to potentially roll this to the last calendar? That's probably only 2 weeks away, but if we could do the last calendar, I think it'd give you plenty of time to work on it.
Okay. And I also like to roll House Bill. Well,
We'll get to that when we get there if you don't mind. But yes, let's, without objection, we'll roll House Bill 864 to the final calendar. Item number 32, House Bill 1308.
I also like to roll it to the final calendar.
All right, you have a second. Without objection, we'll roll that to the final calendar.
Thank you, Chair and Committee.
Item number 35, House Bill 893, Representative McKenzie. You have a motion and a second to recognize.
Thank you, Mr. Chair. This bill simply deletes a date of January 1st, 1980 for persons who've been pardoned and gives them full rights back. That's Again, the bill simply removes that date and allows people that were pardoned for offenses on or prior to that date.
Any questions for the sponsor? Question has been called. Any objection? Seeing none, we're now voting to send House Bill 893 on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You go on the full criminal.
Thank you, Mr. Chair and Committee.
Item number 36, House Bill 0895 by Representative McKenzie.
Could I take this one off notice?
Yes, you may, without objection, off notice. Item 37, House Bill 896 by Representative McKenzie. You have a second? You have a motion and a second. You're recognized.
Thank you. Thank you, Mr. Chair and Committee. This bill, I do admit, is I think it's needed. I know that it is something that I've heard good words from our administration about it, as well as several members of the General Assembly. But I will say, with that, I do think there probably needs to be a little more meat put on the bone. So I would ask that you all would entertain a summer study, one that allowed me as a freshman to figure out what a summer study would be, and but really get into it and bring something back to you all.
Representative Beck.
Thank you, Mr. Chair. I'd move that we move this to summer study, please.
That is a proper motion. It has been seconded. Any objection to a summer study? Seeing none, we're now voting to send House Bill 896 to summer study. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you, Mr. Chair.
Congratulations. Members, let's walk a few places down over to item number 41, House Bill 1346 by Chair Lady Moody. Motion. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman and committee, for moving us up. I do have someone that would like to give a testimony today that is here, so I appreciate your consideration. What Bill 1346 will do, this bill will protect children by strengthening our state's protections against sexual exploitation of minors. This will close a loophole that our courts brought to our attention. And I guess in a nutshell, what was happening was, because as cameras were put in, like, say, a bedroom of one case, I remember the stepfather knew the daughter, 13-year-old, was having a slumber party, put a camera in the bedroom, and was filming the girls as they were getting ready for bed. But he was sharing the videos, and the loophole was that the law said the girls had to be involved in lascivious activity where they were just undressing. So there was nothing we could do. So this will close that loophole. And with that very brief explanation of the bill, I would like to request that my testimony be heard.
Absolutely. Thank you for that explanation. We are going to go out of session. We have someone from the district attorney's office there. If you will, please introduce yourself and tell us who you are and who you represent, and then you will have 4 minutes of testimony.
I am an assistant district attorney in Rutherford County. I'm one of 2 prosecutors assigned to handle nothing but felony child abuse in that jurisdiction. Until and unless we can enact into law the language contained in this proposed bill, we will continue with no good reason to grant a pass to some of the worst cases of child pornography being produced in Tennessee, often at the expense of Tennessee children. And I just wanted to offer the committee a couple of examples of what I'm talking about. I'm currently prosecuting a man who would pose as a minor and kindly solicit a few compromising images from children he met online. By compromising, I mean unclothed to whatever degree. He then dropped the friendly facade and used those photos to extort additional material from his victims. He'd create a Facebook message to victims' parents and friends with the images attached and threaten, all I have to do is hit send, so now you're going to do this. This included one instance wherein he coerced a 12-year-old girl to photograph her 6-year-old little sister below the waist wearing only her underthings. Another case I had back in 2016 involved a Murfreesboro Police Department SWAT sergeant who was secretly photographing his 9-year-old daughter naked in the shower at the behest of a known child sex predator out of Fort Campbell. The sergeant sent the nude images to the predator in the course of their hatching schemes of how they might successfully engage in sexual contact crimes against the 9-year-old in the near future. These cases have two things in common. One, they involve defendants producing material depicting minors for the purposes of their sexual gratification, and two, they do not involve child pornography under the current state of Tennessee law. I actually attended the forensic interview of the 9-year-old victim in the case of the SWAT sergeant. Because the photos did not depict her face, I made the decision to have the forensic interviewer present the victim with sanitized copies of the photos in order to have her confirm that it was in fact her depicted in those images. I will never forget the shock and dismay over her first seeing those photos. Trying to explain to that 9-year-old victim or any other similarly situated victim why deeply unsettling photographs secretly taken of her naked in the shower that were subsequently shared with a known child sex predator, explaining why that does not count as child pornography is a prospect that I find exceedingly hard to swallow. I can't imagine I could effectively explain it any more than such a victim could effectively understand it. Fortunately, this change in the law, a change that was invited by the Tennessee Supreme Court in recent case law, will mean that we won't have to. Thank you.
Thank you. Any questions for our guest? Seeing none. Thank you very much for being here for your testimony.
Thank you very much.
We're going to go back into session. Chair Lady Moody.
Well, I don't know what more I can say. I just appreciate the expert testimony and just know as a mother and grandmother how you would feel. So I would renew my motion.
Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 1346 on the full criminal law. Those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on to full. Thank you. Members, let's go to item number 43, House Bill 802 by Representative Griffey.
Testify or what, I'm fine with that, but I just didn't want to take them up if possible.
Well, Representative, this one is your domestic violence. The first one.
Yeah, both of them, the Safe Act and the animal cruelty. If we just roll them to the last.
You don't wish to proceed with domestic violence today?
No, prefer not to. Prefer to go to the last calendar if we could.
Okay.
Thank you.
That's fine.
Thank you.
Without objection, we'll roll House Bill 802 to the final calendar. Item number 44, House Bill 803. Have a motion and a second on that? Well, without objection, we'll roll it to last calendar. Members, we are on item number 38. House Bill 1416 by Chairman Curcio. Motion and second, you recognize.
Thank you, Mr. Chairman. Thank you, committee members. We talk a lot about in criminal justice, if we're doing something, you'll probably see a fiscal note on a bill, and this is one of those bills. So we are creating the Class A felony of aggravated human trafficking. This is a very important bill in our fight against human trafficking and ending slavery in Tennessee. And I would respectfully request your consideration and move passage.
Any questions for our sponsor? Seeing none, question has been called. Any objection? Seeing none. We're now voting to send House Bill 1416 on to full criminal. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You move on. Thank you. Item 39, House Bill 1086 by Chairman Curcio.
Thank you, Mr. Chairman.
You have a motion and a second. You're recognized.
Thank you very much. I also have an amendment coded 6125.
You have a motion and a second on the amendment. You're recognized on the amendment.
Thank you, sir. And 1 second, I'm going to catch my iPad up to where I am.
Would you like to borrow my pen?
Thank you. Thank you, members. Appreciate your indulgence. Members, what this does is we have a longstanding treatment statute for treatment of DNA evidence and new DNA evidence in the code. This would treat fingerprints largely the same way that we treat DNA. So it would require that a law enforcement agency that discovers potentially exculpatory evidence to report that evidence to the district attorney of that jurisdiction, the trial court, the individual convicted, and the individual's attorney. The idea here is that if there is exculpatory evidence that shows that the person is truly innocent, we do this for DNA already. We just don't have a mechanism to do this for fingerprints. So this would match that up, and I would request your consideration for passage.
Thank you. Any questions for the sponsor on the amendment? Representative Beck.
I was under the impression that this had to be disclosed already. Is that not the case?
Thank you, Mr. Chairman. No, that is not the case, and that's what we seek to remedy here.
Okay, thank you.
Thank you.
Any other questions? Chairman Farmer.
Now, when the state has the obligation, it's my understanding, to turn over all evidence they have, either to prove your guilt or to prove your innocence, which is exculpatory evidence, right? So, on the front end of things, I guess my question is this not happening on the front end when a defense attorney requests for that information to be turned over? It's not been, or is it a post-conviction issue, post-trial issue? I should know this, but I don't. So, just asking.
Thank you for the question. Thank you, Mr. Chairman. No, so right now, the DAs are the only folks that are in possession of that information. That would be disclosed beforehand. This would be on a post-conviction basis if new evidence comes forward. There's just not a mechanism right now. Again, there is for DNA. There's just not for fingerprints. Thank you.
Any other questions? Seeing none, we're now, any objection to the question? Seeing none, we'll vote to add amendment number 006125 on the House Bill 1086. All those in favor say aye. Aye. Those opposed, no. Ayes prevail. We adopt. We're on House Bill 1086 as amended.
Thank you, Mr. Chairman. The amendment made the bill. I renew my motion.
Question has been called. Any objection? Seeing none, we're now voting on House Bill 1086 as amended to send on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. You move on.
Thank you, Mr. Chairman.
Members, we are going to, here in a moment, we are going to conclude for the morning session of the Criminal Justice Subcommittee. We will come back this evening at 5 p.m. in this room to take up the remainder of the bills on this committee. And so, with that being said, we will see you at 5 o'clock. We stand adjourned.